Good morning, my name is Bruce Provan. I'm the Managing Director of Page Provan Family and Fertility Lawyers. We're a firm of lawyers in central Brisbane that practice exclusively in family and fertility law. A large part of my practice is to do with property settlements, and that is division of property between spouses or de facto partners in the event of a separation. One of the questions that we get is, what happens to debts following a separation? How are they treated? In general, to work out a property settlement, one of the first steps is to work out what is the pool. In other words, what are the assets and superannuation and liabilities that has to be taken into account in working out what there is to divide up between the parties. So that requires a careful analysis of the debts and how they're treated. In general, the debts of the parties, whether in joint names or in joint names, are included in working out what the pool is by deducting them from the assets. But there are many exceptions. There's no rule to say that if there's a matrimonial debt that each person pays half. And there's no rule to say that all of the debts of the parties, whether they're joint debts or individual debts, have to go into the pool in working out the available pool for distribution. In relation to joint debts, normally joint debts will go in as a liability to be deducted. It's a bit more difficult in case of individual debts, and in that situation the courts will be a bit more analytical about what debts go in and what debts get left out. So the treatment of debts for family law purposes is not the same as the treatment of debts for commercial purposes. So for example, a couple may separate and they may have a debt to a bank, but the court can make an order to require that debt to be allocated to or paid by one of the parties and not the other party. But unless the court makes a specific order preventing the bank from recovering that liability, the bank still has the right to recover that debt from either person. As I said, debts in individual names require a bit more analysis because sometimes those debts will be taken into account in working out the pool. So for example, if people incur debts for what they call reasonable living expenses, they will normally be included in the pool. If there's debt such as a mortgage, that's likely to be included. Or if there is a joint credit card, for example, or even an individual credit card where both parties have been using, that's likely to be included in the pool. But there may be some debts where a court says, no, well, that debt shouldn't be included in the pool. And that may include debts such as a gambling debt or money spent on unreasonable expenses. Those sort of debts might be either left out of the pool, or the court may say that that debt is to be the sole responsibility of that person. Another example is debts for legal fees. The court generally says that each person has to pay their own legal fees so that legal fees don't go in calculating the assets or the pool of the parties. In some situations, the court may disregard a debt. So for example, if there is a loan between family members that the court considers is unlikely to be enforced, that may not be included. If there's a debt that is vague or uncertain, is unlikely to be recovered, that can be excluded. Likewise, if there's been waste by one person, that is a debt that's likely to be excluded from the pool, and that waste can include, for example, gambling debts, other sorts of extravagant expenditure such as alcohol. There's also tax debts. They will generally be included in the pool if the tax liability has been incurred for joint purposes. In other words, if the tax debt arises from the accumulation of wealth. But there may be other tax debts that are excluded. For example, there may be a tax debt that's been incurred post-separation without the knowledge of the other party. In that situation, the court may order that only one person is liable for the debt. There are some situations where you may have a negative pool, and what that means is that the debts of the parties exceed the assets. But in that situation, the court still can make orders about how that debt is to be allocated between the parties. So the practical effect of debts is that they can either be included in the pool, which is what usually happens. It can be assigned to one party, or a debt can be paid from the assets, or a debt can be excluded altogether in the calculation of the pool. So if you have any queries about debts and property settlement, please contact us at Page Provan. I'm Bruce Provan.